Assalamualaikum madam, my name is Irfan Harib bin Orman. My matric numbers is 079430, and today my group will be discussing about the statistical analysis of intoxications defense in murder cases. My group members consist of 6 people, including me. The first, we have Nurul Aliyah binti Muhammad Faiz, Muhammad Ozi Imran bin Uthman, Lagendra Haroy, Nur Ifah binti Khairul Hisham, Nur Safa Emilia Natasha binti Jafar, and me, Irfan Harib bin Orman.
Greetings, madam. My name is Lagendra Haroy, and my matric number is 076555, and I'm going to present an abstract and introduction for our assignment, which is statistical analysis of intoxication defense in murder case. For abstract, this research employs statistical evaluation of judicial rulings across various jurisdictions to explore the impact of the intoxication defense in murder trials. It examines patterns in the application of intoxication arguments, the frequency of their success, and the factor affecting reduction in charges or sentences. The data reveal significant bias and inconsistencies, indicating considerable variation and based on jurisdiction, the type of intoxication, and the attitude of judges. The study offers recommendation for a fairer application of this defense in murder cases and shed light on the influence of alcohol on criminal responsibility. For introduction of our assignment, in the realm of criminal law, the use of a drunkenness defense has been contentious issues, particularly in cases involving severe crimes such as murder. The basis for this defense is the assertion that a defendant's intoxication impaired their ability to form the required intent, thereby reducing the level of responsibility. The discussion often focuses on whether intentional drunkenness should mitigate culpability of it constitute a form of recklessness that warrants full liability, as different legal systems have varying stances on this matter. The defense of drunkenness is often employed in murder trials with varying level of effectiveness. Despite its controversial nature, jurisdiction commonly make a distinction between voluntary and involuntary drunkenness, with the latter more readily acknowledged as a valid defense. On the other hand, voluntary drunkenness is self-inflicted, and due to the ethical implication of excusing criminal act committed while under its influence, it often faces skepticism from the judiciary. This distinction raises important questions regarding consistency, fairness, and the role of personal responsibility within criminal justice system. This research aims to provide a statistical examination of the use of the drunkenness defense in murder cases, focusing on its frequency, outcomes, and influential factors. By analyzing case data and judicial trends, this study seeks to identify patterns that reveal systemic bias or injustice concerning this defense. Furthermore, the finding will contribute to ongoing discussion about potential legal reforms that balance individual accountability with the effect of intoxication on criminal behavior. That's all from me. Thank you.
For today, we will be discussing 3 objectives. The first one is to study the defense of intoxications under sections 85 and 86 of the Penal Code. Next is to explain the applications of the defense of the intoxications in murder cases in Malaysia. And lastly is to provide a suggestions for developing clear standards for courts on how to analyze intoxications as a defense and a feasible trust strategy to balance justice in public accountability in Malaysia.
Assalamualaikum and hello everyone, my name is Nurul Aliyah binti Faiz and my matrix number is 073694, and I will present about the literature review for murder. Penal Code is the law that governs murder and culpable homicide that does not amount as murder in Malaysia. To establish an offence, there are 2 general requirements that should be met, which are a wrongful act, which means actus reus, and intention to commit the act, which is mens rea. This is based on the maxim actus non facit reum, nisi mens sit rea. Knowledge, like intention, cannot be directly proven and must be inferred from the objective facts or admission by the accused. The prosecution must present facts that reasonably support the conclusion that the accused had the necessary knowledge to convince the court. A human death caused by an act or omission with the knowledge or intention to cause death is one of the offence's elements. Whether an act qualifies as murder or culpable homicide depends on the mental condition of the person who caused the death. Additionally, murder is punishable by death under Section 302 of the Penal Code, while culpable homicide is punishable by up to 20 years in jail under Section 304 of the Penal Code. One case involving this matter is Kumar Tamang and public prosecutor, in which the appellant killed the deceased with a large stone, causing the deceased to collapse to the ground with blood seeping from the wounds on his head. So according to Tamang's act, it constitutes actus reus, which is acting something that caused injury to someone. According to witnesses' testimony, the appellant intended to cause the deceased serious harm by carrying out the act that resulted in death. The appellant exerted intoxication as a defense, but failed to meet the burden of presenting medical burdens and was unable to prove it through the submission, as sought by experienced counsel, which is proven that the Kumar Tamang failed to prove it beyond any reasonable doubt.
Now I'm going to talk about the defense of intoxication. So the defense of intoxication in murder cases has been widely debated in criminal law, especially due to its relationship with mens rea, responsibility, and fairness. This literature review examines existing research and case laws to explore the implications of intoxication as a defense, including voluntary and involuntary intoxication, with emphasis on case outcomes and the impact on legal principles. Intoxication often hinges on the distinction between specific intent and general intent crimes. Most courts tend to exclude voluntary intoxication as a defense, particularly when assessing mens rea for murder. In Montana against Egelhoff, the U.S. Supreme Court upheld Montana's exclusion of voluntary intoxication as evidence, arguing it aligned with public policy and accountability principles, thereby underlining the judiciary's resistance to allowing self-induced intoxication to invalidate intent in serious crimes such as murder. Similarly, in Brennan against HM Advocate, the Scottish courts maintained that deliberate intoxication could not excuse someone from criminal responsibility or serve as evidence of automatism, even in severe cases where drunkenness affects cognitive abilities, as individuals who intentionally intoxicate themselves remain accountable for their actions. In jurisdictions that differentiate between specific and general intent, intoxication may affect the former but rarely the latter. For example, in People against Mahle, the court allowed evidence of intoxication to determine whether the defendant possessed the specific intent required for first-degree murder, demonstrating how courts occasionally consider alcohol as a mitigating factor while still upholding criminal liability. This legal nuance is further illustrated by People against Kolber, where the New York court acknowledged that voluntary intoxication does not absolve liability but may affect premeditation or the defendant's capacity to form specific intent. The adequacy of jury instructions remains a recurring issue in intoxication defenses. In Right against Commonwealth, the Supreme Court of Virginia ruled that the trial court erred by failing to instruct the jury on the role of voluntary intoxication in first-degree murder charges, highlighting the importance of ensuring juries understand how intoxication can influence intent without excusing criminal behavior entirely. Ethical concerns and policy considerations often shape judicial decisions, with courts and policymakers frequently citing the need to deter reckless behavior and prevent individuals from using intoxication as an excuse for violent crimes. This approach was reinforced in Montana against Egelhoff, which reflected society's desire to hold individuals accountable for self-induced states. And however, exceptions exist for cases involving settled insanity, where prolonged substance abuse leads to a persistent mental state that may qualify for an insanity defense. Unlike temporary intoxication, settled insanity reflects a long-term impairment, creating a nuanced distinction in criminal law. Despite the clarity in principles regarding voluntary intoxication, gaps remain in the literature, particularly in comparing how jurisdictions address involuntary intoxication and its impact on murder cases. Additionally, inconsistencies in jury instructions and court rulings across states point to the need for standardized legal frameworks.
Moving on to the discussion part, my name is Nur Safa Natasha Binti Jaafar. My metric number is 079201. So basically on this part, the overview is research on focus of statistics and applicability of intoxication defense in murder cases in Malaysia under sections 85 and 86 of the Penal Codes of Malaysia. And we group as a group has found 62 cases from 2010 and 2023, which is 30 years of cases of murder that use defense of intoxications in murder cases in Malaysia. Okay, as you can see next in this slide, where we collected these data on murder cases that use intoxication defense as their defense. So the success rate for this case is remarkably low, and only 50% out of 100 of murder cases invoking this defense succeeded over the 30 years period. So this is the total case of our research, which is 62 cases, as I had mentioned in the previous slide. And okay, we're moving on to the next contents of Objective 1, where to study the defense of intoxications under sections 85 and 86 of the Penal Code. And first point is judicial interpretations of section 85 and 86 of the Penal Code. So our research focuses on how courts interpret and apply these provisions and analyze judicial decisions and statistical trends from 2010 to 2023 that to highlight both challenges and implications of this defense. So the defense of intoxication can be invoked in criminal cases, including murder cases, but it is subject to strict limitations. And under sections 85 and 86 of the Penal Code, it provides the legal framework on how to apply this defense under the criminal cases. So, such as in the case of Woh Poh Ling and public prosecutor, and the case of public prosecutor against Edwin Rojas Zaz, where the courts held that inconsistencies in interpretations and challenges in provoking the intoxications defense. We also can distinguish between the voluntary and involuntary intoxications, where under section 85 clause 1 states that intoxication is generally not a defense except under specific circumstances, and under section 85 clause 2b, however, allows the defense in cases of involuntary intoxications where the intoxicated state induced temporary insanity. So basically, our study revealed that Malaysian courts often reject voluntary intoxication as a valid defense. And this is evident in the case of Kenneth Fook Moon Lee against public prosecutor, where the court emphasized that voluntary intoxication is seen as reckless behavior, and that does not an excuse for criminal liability. So the courts prioritize public interest and accountability, holding individuals responsible for their actions taken under the influence of intoxications. But in contrast, involuntary intoxication is treated differently. So because this defense is allowed if it can be proven that the accused unknowingly or they didn't have the knowledge that the time they consume intoxicant materials as a result, and they experience temporary insanity. So, for example, in the case of public prosecutor against Yusuf bin Saruan, the accused argued that he was unaware of consuming intoxicants materials, so which leads to a state of temporary insanity of him. So the court accepted this defense and ruling that involuntary intoxications negated the intent to commit murder. So, however, as I had provided the statistical findings specifically in year 2017, most cases invoking the defense of intoxication are unsuccessful, and it was hard to prove that the accused was in involuntary intoxication state. So, in 2017 alone, 60% of such cases failed because defendants could not meet the high burden of proving involuntary intoxication or temporary insanity. So, in a few notable example of cases of Sankar anak lelaki aspirant against public prosecutor, here the accused argued that heavy intoxication impaired his judgment, making it possible for him to form the intent to kill. However, just because the intoxication was voluntary, the court rejected the defense and reinforcing its strict interpretation of sections 85 and 86 here of the Penal Code. So this is how the cases lose the win of the case because of the voluntary intoxication state. So our findings next highlight several challenges and implications. First, there are significant limitations in proving the defense of involuntary intoxication or temporary insanity. So sometimes the court imposed a high burden of proof requiring a clear evidence that the accused intoxicated state was not self-induced. And secondly, judicial approaches to intoxication defense are inconsistent, which is leading to the gaps in the legal applications. And lastly, the court emphasized on personal accountability and public safety, where they ensures that voluntary intoxication is rarely accepted as a defense, reflecting the need to discourage irresponsibility of substance used by the accused. So, in conclusion, for my part, while the defense of intoxication plays an important role in certain cases, it is narrowly defined that and difficult to prove uh, on using this defense. So, this approach balances a public interest with individual accountability, but it also raises questions about fairness in a few cases where intoxication generally impairs judgment. So these challenges underscore the need for continued examinations of this area of law to ensure justice is served. That's all for my part. I will pass to the next presenter. Thank you.
So hi, Assalamualaikum everyone. My name is Nur Binti Karisham with metric number 077220. So I will explain about the objective, which is the objective 2 of this presentation is to explain the application of the defense of intoxication in Malaysian murder cases, particularly how the judiciary balances public policy with justice. There are two key principles regarding the defense of intoxication, which is the first one is voluntary intoxication and the second one is involuntary intoxication. For the first one, which is voluntary intoxication, this applies when accused willingly consumes alcohol or drugs. It is only relevant in cases of specific intent crimes like murder, where it can disprove mens rea, the intent to kill. However, it is rarely accepted as a full defense, as allowing it would undermine the law's deterrent purpose. And the second one is involuntary intoxication. This occurs when the intoxication is not self-induced, such as through spiked drinks or adverse effects of medication. Courts are more likely to accept this defense, provided it that can be proven that the accused lacked the intent to commit murder. So let's look at two case examples that illustrate how the courts apply these principles, which is the first one in the case of Kumar Tamal against public prosecutor 2021. The court rejected the defense of intoxication. The accused had voluntarily consumed alcohol but was still conscious enough to form the intent to kill. The court ruled that allowing voluntary intoxication as a defense would weaken the deterrent effect of criminal law. In contrast, in public prosecutor against Bukhari bin Jainal 2021, the defense was accepted. The accused had taken prescription medication that caused involuntary intoxication, resulting in extreme disorientation and mental impairment. The court found that the accused lacked the required intent for murder and reduced the charge to culpable homicide. So, from a dataset of 62 cases between 2010 until 2023, the defense was rejected with 85.5% of cases involving voluntary intoxication. It was accepted in only 14.5% of cases involving involuntary intoxication. These statistics shows that Malaysian courts adopt a strict stance on voluntary intoxication while considering involuntary cases more leniently. So, in conclusion, the Malaysian judiciary balances public policy concerns with justice, which is the first one, voluntary intoxication, it is rarely accepted in the defense because it undermines the deterrent effect of criminal law. Courts may consider it as mitigating factor in sentences, but not as a justification for the crime. And involuntary intoxication, on the other hand, can be a valid defense if it can be proven that the accused lack of intent. And the third objective of this presentation is to propose clear standards for courts to analyze intoxication as a defense while balancing justice with public accountability in Malaysia. So through an analysis of 62 cases from 2010 until 2023, several challenges have been identified. The first one is a low success rate, which is only 14.5% of cases successfully use intoxication as a defense, primarily for involuntary intoxication. This highlights the difficulties defendants face in meeting the burden of proof. And the second one is burden of proof. For example, in the case of Pendakwa Raya against Muhammad Ishaq bin Alias 2010, the defense failed because there was insufficient medical evidence to prove the accused's mental impairment. This case illustrates the need for clear and reliable standards for medical experts' evidence. And the third one is public misunderstanding. So many accused individuals are unaware that voluntary intoxication is almost never accepted as a defense for serious crimes like murder. This lack of awareness can lead to misuse of defense and false expectations. And the last one is substance abuse, which is in several cases, voluntary intoxication was linked to underlying substance abuse problems. For instance, in the case of public prosecutor against Tung Kok Heng 2011, the accused's long history of alcoholism contributed to their behavior. This raises the need to address addiction as part of the broader strategy. So to address these challenges, I propose three key recommendations, which is the first one is standardized evidence guidelines, which is court should adopt uniform procedures for handling medical and expert evidence in cases involving intoxication. These include a clear protocol for expert witness testimony and standardized medical reporting to assess the accused's mental state. And these guidelines will ensure consistency and reliability in determining whether intoxication genuinely impaired intent. And the second one is public legal education. So implement public awareness campaigns to educate individuals about the legal consequences of voluntary intoxication. For example, emphasizing that self-induced intoxication rarely absolves one from criminal responsibility, particularly in a murder case. Such education discourages reliance on voluntary intoxication as a defense and reinforces the principle of accountability. And the third one is rehabilitation programs. So courts should consider integrating rehabilitation program into sentencing for offenders whose voluntary intoxication stems from substance abuse. This approach addresses the root causes such as addiction while balancing accountability and deterrence. Rehabilitation not only reduces the risk of reoffending but also aligns with public interest for promoting long-term behavioral change. So in conclusion, these recommendations aim to improve the management of intoxication defenses in Malaysian courts by establishing clear evidentiary standards for assessing intoxication. Second, raising public awareness to minimize misuse of the defense. And the third one is incorporating rehabilitation as part of sentencing for cases linked to substance abuse. So by implementing these measures, we can ensure a fair and consistent legal procedures that balances justice and public accountability. So that's all from me. Thank you.
In conclusion, the statistical analysis of the defense of intoxications in murder cases under Malaysian law brings into highlight some serious difficulties and challenges in its applications. Regulated by each section 85 and 86 of the Penal Code, this defense has rarely succeeded in most cases endorsed by courts. Only a tiny percentage has successfully fulfilled the strict threshold of being endorsed. Courts often rely on individual accountability and public protections, particularly in cases where defendants are culpable for their actions even under voluntary intoxications. The results indicates the need for strengthening coherence and equality in judicial interpretations and possible legal framework adjustments to minimize system defects and biases. By reconciling the foundational principle of justice with the practitioner consideration of dismissed judgments resulting from intoxications, the legal framework may strive to arrive at more equitable results in homicide trials that incorporate this defense. Thank you.